was recognized as a common law writ. It then came into the 1967 Constitution and was maintained into the 95 Constitution. But it has two limits. One has been satisfied. And perhaps the most common one that has been satisfied is that the person has appeared here. But like in Injira's case, it was known where Prince Injira was being taken. It wasn't a case of, the common thing where people sort of disappeared. Where he was. Just like it is known where his applicants are. In fact, we did not say much because when they came here, they were in the company of other officers of the state who have actually. So we were able to tell where in custody. We knew where they were. So the first thing is bring the body. Sometimes we feel whether the second thing, what we my Lord, the Supreme Court did not say that those who are incarcerated should remain incarcerated, except for those who had been convicted. One might argue,
for example, I was thinking we needed to consolidate these two applications. So you have said for Kizza, since he was convicted,
that case is actually different and you will not win it up now. Those who had been convicted, unless they are challenging the conviction. I believe my land friend is very vigorous. So there is no way in the judgment where we are saying those who are in detention stay there until such a time that the government decides that you find the competence court and transfer those files. So this application is brought with that idea along that argument in mind.
I wish we can get the chair for the AG staff. They need to write something. They have to write
So my Lord, one of the orders that was raised is that these tribes seize and be transferred. In there, they could have had seize That is the that is the reason for detention. Contain the person. Is not on the is not on the
Court X on date Y told us to keep the body of these individuals until we go back.
I have not seen it. The second possibility is that they are, and this is the charge sheet. I know those pending charges can't come from the court martial. Because some of the offences in the UPDF can't be tried in the civilian courts. There are offences there that are very different, very different character, and they don't exist in the penal code. They can't be tried in this normal civilian courts. So they would have brought a charge sheet which says, you in court X, they are pending charges. This is the reason why these people are. What do they refer to? They refer to the Supreme Court decision, which did not say keep them here.
Maybe it's the AG will have to carry
So
the cross.
I want to submit, my Lord, and I hope that you will be persuaded that the response from the Attorney General falls short of justifying the reason for denying the applicants their personal liberty. Since the 31st of January 2020, it says nothing to you, my Lord, that explains why
This court is clothed with that power. Because the power is unfettered.
it is so unfettered it can be applied immediately. Clothed with the power to order the release of these applicants. Today, if the state has a lawful reason, let it act lawfully after those orders are given. They deal with the issue, whatever the issue is. My lord friend has made reference to section 15 of the Human Rights Enforcement Act. I am aware, my lord, you are perfectly familiar with that space, and I very respectfully urge you, my lord, to find merit in this application and grant the orders. So, my lord, Honorable Sekona, you want to just wrap it up?
How many minutes do
My Lord, I will request for only 2 minutes. Except that I will request that the officer instructing your view of the my body language. You were told that you need to look at it. And not just to sum up. Section 57, which has been cited by Madam Friends in all of areas of work, is instructive. A prison's officer can only detain a valid warrant issued by a competent authority, in this case court. Upon the demise of the General Court Martial, it is very clear that the power of the General Court Martial order detention collapsed. It collapsed in the presence of the Attorney General of the Republic of Uganda, who is the first respondent to this application. No man.
Saying it was not
No man.
saying it was not necessary, but saying so many words.
I am not even wanting to go there.
I am only restating the position of the Constitution. Under the Constitution, liberty is guaranteed. Restriction must be justified. And that justification must be lawful. And in this particular case, the lawfulness should not be cemented on an order, on the valid order of a court with competent jurisdiction. In the absence of it, there is no justification, and it is your power, madam, and duty to order freedom to be reinstated. Away from the Prisons Act, my lord.
Okay. Because some people, your politicians, the Lord Mayor, a former teacher, are putting me under some weight that I should do now. They need to write it. Why write it?
My lord?
Can you address that?
Yes.
I can write it.
Yes, my lord. Yes, my lord, now is contextual. And what we are saying by now is that upon conclusion of our service, the court be pleased to begin writing the release order. In the same realm of context, my lord, I now propose to take you to the context of the Supreme Court's order of transfer, which has been disposed of. My lord, this must be looked at from the perspective of Article 120 of the Constitution. The Supreme Court did not order the Director of Public Prosecutions to take over, because that is barred by the Constitution, Article 120. In effect, the Supreme Court told the first respondent, if he's interested in any prosecution, to go and start de novo. Start, do a fresh investigation, a fresh complaint. What one would expect is the state to report to the nearest police station or post and report and start with first information. Why? Because any warrant of court has an expiry date and tenure.
During the 50 minutes, you can ask for another constitution.
Ballot. With your permission, and I'm grateful. Because the DPP cannot itself has a time limit. Bring back this person on this particular day. That is axiomatic. The moment it expires, lawfulness ceases. In this particular case, the warrant of the defunct marshal was actually in itself expiring on the third day of February. They could not extend or even terminate because they had ceased to exist. And since that time, the lawfulness, if at least it had not collapsed on the 31st day of January, died or redied. To contextualize Act 120 and the decision of the Supreme Court, I would implore you to apply the decision of the East African Court of Appeal in Incase versus Musiramo and another.